Delivery of orders, item number 1 and 2.
Both the bail application number 1632 and 1633 stands rejected. Both applications rejected.
Obliged.
Motion, item number
So
3. Acha, one request was there for VC. In fact, I don't know.
Side of the Advocate General Mizoram Lordship.
May I please, your Lordship, madam. Lordship, I beg to mention item number 23, Lordship. Kindly the matter may be listed after vacation. Consent
20?
has been taken, your Lordship. Item
23?
number 23, yes.
You are for the,
But I am for the victim girl petition, Lordship.
so you are appearing on behalf of Mr. NNB Chaudhary or what?
He's out of petition, Lordship.
Okay. To allow for you. Mr. Bora he was there, I think.
I am for the
You are for the
petitioner.
petitioner. So have you taken consent with the other side? With the consent of the other side, then the council appearing on behalf of the petitioner, paid for an enjoyment. Is the after vacation it
After
will be
vacation, Lord.
list accordingly after vacation. Okay.
May I please, Lordship? Lordship, I beg to mention item number 9, madam. This
9.
item 9 from
Ah.
the list.
Yes.
This matter maybe come up any other day, madam, before vacation. Conducting council.
The date I cannot say because this is
Before
not
this-
the temporary bench, this is a temporary bench. And that apart, after a week, let it be.
Before vacation, madam, is possible.
We'll try to before vacation, list the matter. Preferably as on a date to be fixed by the after a week, as on a date to be fixed by the registry, preferably before vacation. Okay.
Obliged.
Maybe Lordship. Hello, I beg with liberty to withdraw the matter, item number 18, madam. We have put the appellant, RFA matter,
Item number 18.
18, madam. IAS.
You want to withdraw this
Withdraw
one?
this, madam. Execution proceedings going on.
Otherwise, here one most probably the delay condemnation petition was there. So you are for the appellant. C. Chakraborty. Hard Mr. Chi Chakraborty, the learned counsel for the petition. Oh, sorry, appellant. Anyone respondent? You are Mr.
Hassan on behalf of B. Sharma.
M. Hassan appearing on behalf of Mr. B. Sharma, the counsel for the respondent. Is submitted by Mr. Chakraborty that as per instructions of his client, he wants to withdraw the present RFA. The post of list the prayer allowed, this matter is accordingly disposed of and withdrawn. Oh,
Shall be sent back.
pardon?
And share may be sent back. And share is
As shall be sent back according.
It please your honor, I beg to mention item number 12 of the daily list. Your honor, the matter has come up today, but our names are not reflected in the
Ah,
list. You have come to know today. Maybe, your honor, there is certain urgency in this case because the case in the lower court is fixed during the vacations. Maybe taken up any date before the vacation, probably on Friday.
Friday, I don't know, Friday may not be possible.
Any date before the vacation.
Next Monday is okay. Otherwise, you are appearing for the petition.
Petition.
And the other side, the private respondents are there, no?
Only one respondent is that they have not appeared in the, there was a connected IA for condemnation of delay that was disposed of, so they had not appeared there.
But after the disposal of the condemnation petition, have you taken any steps? No.
During the IA I had taken up this time, no.
Thereafter also you have to take. Anyway, how you are, Mr.
G. Kaushik.
Hard Mr. G. Kaushik, the learned counsel for the petition. And it is submitted as the cause list, as the names of the counsel for the petitioner as well as respondents are not reflected in the cause list. The matter could not be prepared today. Stop. Considering this submission made by learned counsel for the petitioner list the matter accordingly on Monday is the 23rd.
Mm.
To 23/06/2025. Registry is hereby directed to reflect the name of the councils for both the parties.
Your Honor, another case is the same parties and same case, that is not come, criminal revision petition 221/25, that also may be
That's
tagged along,
criminal revision petition
221/25,
221
221,
of 25.
25.
Tag the matter along with criminal revision petition number 221 of 2025. Okay.
Oblige.
May it please your lordship, appearing for the petitioner. Item 3, lordship.
Oh, yeah, item 3.
Yes, I am
Ah.
appearing for the petitioner.
Okay.
Lordship had indicated some BC.
Yes, Lordship.
Yes.
And
So can,
Advocate General Mizoram, he will argue the case, Lordship. So that's why I have applied for BC, Lordship.
Online.
have you sent we are going to send the link now. So we'll take up the matter of 4, item number 4, then we'll link it up. Because link we have not sent, link to the Pothwa hoise niki already. It may take some 5-10 minutes, that's why I'm just.
Grateful.
Item number
4.
3.
No, 3 number 4.
Item number 4.
May I please your lordship? Your lordship, this is a revision petition with regards to one single date of non-appearance with regards to the engaged council, your lordship. The matter is a state CR.
Have we annexed all orders?
Indeed, your lordship, all orders have been annexed, your lordship. The last order clearly reflects that the engaged council has appeared, and moreover, your lordship, if your lordship may come to page number 21, your lordship, the accused persons were allowed to be on advocate representation, your lordship. And as per annexure number 21 and 22, thereafter on 6th, only one single date, your lordship. On 6th, the engaged council was unable to appear due to certain climatic conditions, your lordship. And therefore,
Specifically, which date you are talking about?
we're talking about 6th of June, your lordship. 6/6/2025, your lordship.
6/6 to 2025.
5, indeed, your lordship. Page number 15 is the impugned order, your lordship. And the date prior is page number 26, your lordship.
Date prior is page
Page
number.
number 26, your lordship. There it is clearly mentioned that we have represented, your lordship. One single date, your lordship.
So on that day,
On
PW10 was also examined.
examined, your lordship, and this on if your lordship may produce page number 21. As per page number 21 on 13th of July 2023, because both of them are government servant. One is was serving as the general manager and the assistant general manager at APGCL, and thereafter they were allowed to be under advocate representation. On 6th, only the advocate was unable to appear, your lordship. It is not connected with the accused person directly, and only on one occasion, because due to climatic condition, when they could not reach the court in due time, your lordship, and NBW was the year what so.
Your name is not reflected here.
Ashraful Barbu here, TL also. I have signed the Wahalatnama, your lordship.
You are not Ashraful, I think.
I am advocate Tohid Laskar, your lordship. T. Laskar,
T. Lashkar. Heard Mr. T. Lashkar appearing on behalf of Mr. Ashraful Borhuya for the Direct Counsel for the petitioner. And also heard Mr. D.P. Goswami, the learned additional BP, appearing on behalf of the state respondents. This is an application under section, this is an application under section 438 and 442, read with section 528 of BNSS against the impugned order that is 6/2025, whereby the NBW were issued to the present petitioner. Both the petitioners are here before us.
Need your lordship. Both the petitions are before us.
Post on. Next para. It is submitted by Mr. Hussain that the accused petitioners were regularly appearing before the learned trial court below. And on 21 is the order, no? Your representation was allowed.
Allowed, your lordship.
Page 21.
Page 21. Order dated 37, Your Lordship.
And
13/7.
right, order dated 13/07/2023. The prayer for representation under section 205 CRPC was also allowed by the learned trial court below. And accordingly, both the petitioners were under the representation of their NBS counsel. However, on 6/6/2025, the petitioners as well as the learned NBS counsel could not appear and they remain unrepresented, and for which the NBW was issued against both the petitioners. Next, madam. Mr. Hussain further submitted that the petitioners are regularly appearing before the learned trial court below, and case was also at the stage of evidence wherein 10 members of PWs have already examined by the prosecution. Here, MBW was issued, no?
Indeed, Your Lordship. Waiting for
And both the petitioners are also ready and willing to appear before the learned trial court below and to complete the case accordingly. If they order for, if they are protected with some interim protection, if they are protected with some interim protection. If they are protected with some interim relief, full stop. Next, madam. Mr. Goswami, the learned additional PP submitted in this report that from the order sheets annexed along with the petition, it reveals that the petitioners were regularly appearing before the learned trial court below, and or they were representing day by day learned NBS counsel, and hence considering the conduct of the accused petitioners, the prayer may be considered accordingly. Next, madam. In view of the submission made by learned counsel for both sides and also on perusal of the record, especially the order sheets filed along with the petitions, I'm of the view that one more chance may be given to the present petitioners to appear before the learned trial court below and to contest the case accordingly. In view of this, the order dated 6/6/2025 is accordingly the order of NBWA issued against the present two petitioners are hereby suspended. When the case next date is fixed, 4/7. Suspended with a direction to the petitioners to appear before the learned trial court below on or before the next date of listing.
Much obliged.
With the above observation, the instance disposed of. Okay.
Much obliged.
Item number 3.
They have not joined yet. Need to highlight.
But I'm here.
Both audio and video are not working.
Am I audible, my lord? Am I audible?
Yes, you are audible, but
I'm not visible.
not visible. Yes.
There's some problem with the video. It was there just now, but there is some problem. I'm connecting. In the meantime, if your lordship can kindly allow me to,
Otherwise, you are audible.
if your lordship can kindly allow me in the meantime to submit. I'm trying to connect. I'm trying to connect the video also.
Okay. Yeah, otherwise you are audible.
Let the petitioner,
We can hear you.
let
Okay.
the petitioners learned counsel submit first.
Yes, yes. May it please your Lordship.
Yes.
Now, Lordship, I am appearing for the petitioner company,
Mm.
Mahindra and Mahindra Finance.
Mm.
And this is a petition under section 447 of the BNSS. We are essentially seeking transfer of two proceedings arising out of FIR 3 of 2024 and
One is FIR 3 of
3 of 2024, which is annexure 4 at page 40. And proceedings arising out of FIR 96 of 2024, which is annexure A3, page 31. We are seeking transfer of proceedings arising out of these two FIRs from Aizawl to competent court in Guwahati. Now, before I proceed on the merits of the case, let me just briefly, Lordships, apprise Lordships, what is this case about and why is it so important? Now, this is a case which pertains to 150 crores auto finance scam that happened in the state of Mizoram. Lordship will appreciate that we are a finance company. We are essentially into financing vehicles, SMEs and others. So in the context of Mizoram, which is a small state, 150 crore scam has its own ramifications. The scam worked in this manner. Our employee, in collusion with car dealers, they manufactured fictitious loan applications. Fictitious loan applications were submitted to the head office for sanctioning of the loan. The loan was sanctioned. The money which was sanctioned was deposited into a Mahindra and Mahindra Finance account, which was again fictitiously opened in Mizoram Rural Bank by forging signatures. So essentially what happened was vehicles were never sold, vehicles were never delivered, but we went on financing those vehicles.
So many vehicles were not delivered.
There were no vehicles. These are all fictitious. Everything was fictitious. So no way, and this was done by some employees of our company, along with the bigger auto dealers of Aizawl. This was a collusion between them. So when this thing blew up, when in our internal audit, we said, where are those vehicles which we have financed? And there was nothing on record. So naturally, at that point of time, our authorized representative, Mr. Ankit Bagri, kindly note this name, Ankit Bagri, who was then overall in charge of the operations of the Northeast, he filed a complaint to the Mizoram police to investigate this offense. And that is the first FIR, which is annexure A3, page 31, if Lordship may see. In fact, Lordship will directly come to page 34, which is my complaint on the basis of which the FIR got registered. I'm just pointing this out because what is actually the fact. Now, Lordship will kindly see para 2 of that complaint at page 34. During a routine verification, we asked our area business manager, Mr. Zakir Hussain, he is the prime accused, mobile number so-and-so, who had sanctioned below mentioned loans, which were processed through his subordinates, Mr. Joseph and Mr. Eden Thara, to submit B-extract registration certificate of the vehicles in question. But to our surprise, all PDF copies provided by Mr. Zakir Habibur Hussain show same QR code with different numbers. Certificate submitted by Mr. Zakir Hussain appears to be fake. Further, we suspect that our employees colluding with dealer of the car dealerships and his representatives, the board and directors, as well as some unknown accused persons have cheated our organization. Due to these actions, the company have not had any security hypothetical vehicles under these contracts. People have misrepresented with the help of forged RTO records to avail the loan from Mahindra Finance. The amount financed by Mahindra Finance in these 9 cases was approximately 62 lakhs at that point of time. And then further investigations came in We are apprehensive that these 9 cases are just tip of the iceberg, and we apprehend that this is just a small part of the big pre-planned fraud committed by our above stated employees with help of others, causing wrongful loss to the organization and to get wrongful gain for themselves. So this is essentially the first FIR. Then, of course, we at our company level created our own investigation and audit, and then we came to realize that it's a much bigger scam. And that led to the filing of the second FIR on a separate charges, which FIR is at Lordship's Annexure A4. And Lordship will kindly come to page 43, the essence of our complaints. This is 29/3/2024. And this is filed by the business head of Mahindra and Mahindra Financial Services Limited. May I just place from para 2? During a routine verification, we have come across large-scale fraud and forgery committed by our area business manager, Mr. Zakir Habibur Hussain, in sanctioning many vehicle loans at our Aizawl branch. The broader scrutiny of the records of the branch in the aftermath of serious fraud committed by branch manager Zakir Hussain and his co-conspirator, I have discovered that the official identity has been impersonated by Mr. Zakir Habibur Hussain and his co-conspirator, Mr. So-and-so and so-and-so, and have created a fake entity, that is Mahindra Finance Limited, with a similar description as of my company, and executed fraudulent transactions, including in cash in crores, through this fake entity set up through his co-conspirators. And please see the details of the fake bank they started. Same, Mahindra Finance Limited, Mizoram Rural Bank. So the extent of the fraud is now they have opened up a bank, the money gets into that. I would like to inform you that I've never opened or operated the above account, and the same has been opened and operated by aforementioned accused persons with the aid and assistance of employees of MMFSL Aizawl. And para 7 Lordships will see a bare perusal of the account statement of the said fake account reveals that there are transactions of more than 80 crores in the said account within a short span of nearly 3 years. The act said that prima facie indicates so-and-so commission of such and such offense. Now, these 2 FIRs came to be investigated. Now, my first ground on which, because Lordship will see the test that has been laid down by this court or by the Honorable Apex Court is a test of reasonable apprehension. That whether I have an apprehension and whether it is reasonable arising out of the facts and circumstances. So my endeavor today, Lordships, would be to indicate those facts and circumstances based on which I have a reasonable apprehension that I may not, because ultimately I am the victim of the fraud, may not be getting justice that I deserve. Now, please kindly see. So, therefore, my first submission for your Lordship's consideration, and that I will place it, I will demonstrate it from the record, is every action or rather inaction on part of the state, both during investigation and trial, is probably inuring to the benefit of the accused. And I am saying this with a lot of responsibility. The Advocate General is here. I am not saying the state is conniving. We are not saying that the state is conniving. But the way the state is conducting itself is definitely very lackadaisical.
Well, I'll come to my submissions later on.
Yes.
But I place my objection to this particular statement of the learned counsel who has been appearing for the petitioner.
We are not saying
because the state had already arrested more than 20 persons. Charge sheet has been submitted. Trial is going on. I don't know the reason why they have come up with such a transfer.
Yes.
And I question the maintainability of the said petition, because when there is a bench in Aizawl, I don't find the reason why the petitioner has come up before your Lordship and wasted the time of this honorable.
May I continue, Lordship? Leadership, may I just continue?
Yes.
Now, in respect of my first submission, please kindly have a look at Annexure A5 at page 47. I am now indicating those we initially did not come, but now situation have reached such a stage that we have to approach your court, Lordship's court, that we need a transfer. Now see how things have panned out over the whole period. Please, for the first time, please see Annexure A5 at page 47. And
Yes. Yes.
Now, this is an order passed by the learned CJN on a remand application. The arrested persons, namely so and so are produced before court at 2 p.m. in connection with the case. Now, please mark the next line. Also seen prayer submitted of the case for remanding the arrested person into police custody for 5 days. However, the case IO is not present in court and the arrested persons were produced by Constable so and so. PI is also absent. In such a high profile case, this is your conduct in the court. Now, please turn over, Lordships. Please come to page 48. This is even more interesting and more glaring. The council strongly, the council strongly objected the remand and submitted that the arrest is not legal, as the arrested persons were not arrested in compliance with the mandatory provisions of law. That is the argument of the accused persons. Now see our response, the state's response, not ours. The council present also agreed that there were lapses in the manner in which the accused persons were arrested. This is the prosecution saying the court. Next, on
No, this is not the, I beg to differ.
Please do not
I beg to differ, my lord.
I will
My
not
lord, the
interfere.
council present. It is not a statement on behalf of the.
May I just
state.
request not to interfere?
It was not from the public prosecutor, my lord.
Lordship,
My
I
lord,
cannot argue
my lord
with
will come to the
if
next
there's
paragraph.
interference like this.
On inquiry
Give
from
me
the
a chance to rebut. Why is it interfering every time?
No. You are.
I see that. I quite see the anxiety of the AG.
I am sorry to say you are misleading the honorable court.
I don't see why the
I am
AG
sorry
is so
to say
anxious.
you are misleading the honorable court.
I am reading from the record. It's a judicial order. What is there to mislead?
No.
It is a judicial order, Lordship.
You are saying that the next para, the council present
Lordship,
also agreed.
Well, Lordship,
It is
you
not
did
the
now.
submission of the
If
state.
I am not
The
able to.
submission of the state comes to the next paragraph.
I don't see why the AG is so anxious. You will get your chance, sir. Please
I know that.
me conclude
I know
my
that.
arguments.
I know that, but I also expect a fair argument from you.
Lordship, I'm reading a judicial order. It is not my construction of a page. Now, Lordship will kindly see the next page. On inquiry from the APP regarding the arrest, he submitted he has no knowledge regarding the arrest of the two persons, and they were not given any prior information on the arrest of the two persons produced before the court. So this is the interaction between the prosecution police and the officials. Now the next line is even more important. Heard the submissions, also examined the prayer and connected documents in connection with the arrest. The prosecution has few submissions as they were not given any prior information from the concerned investigating officer or the police station regarding the arrest and has little knowledge regarding the arrest. Now, Lordships, very well it could have happened that bona fide there was a communication gap. What would I as a victim expect? That the state goes up in appeal against this? So ultimately the remand was quashed. If Lordship will see the last order, the last two lines of that same page. Accordingly, let the arrested person be released from custody and prayer for 5 days remand is hereby rejected. Application prayers. So ideally, I as a victim of the offense would have expected the state to
Release from custody means what? Police remand is not allowed, but whether they were in judicial custody.
They were in custody. They were just arrested and brought.
So they were sent for judicial remand.
No, they were released.
Huh?
They were released. They were
Released?
released entirely. On the same day. Now you see the next line, next page. However, please see the next line. Next page, the top two lines. Next page, Lordship, top two lines, this is clarified. However, the investigating agencies are liberty to take legal recourse afresh, again, including arrest. So one would have expected in such a serious case, the state would have gone up in appeal against this. But they were very happy with this order. They did not go up in appeal. It is we who went up in revision, saying this order is wrong, which was the primary duty of the prosecution. The prosecution doesn't go up in revision. Lordship will mark it. That is why my first submission is that every action or inaction is basically inuring to the benefit of the accused. Now see the revisional order. Next annexure, which is annexure A6 at page 50. This is the revisional order which we filed, which the state should have filed. In of course, where of course the revisional court set aside that order. Set aside that order, and the law took its own course. So what I'm trying to point out is that where it was duty of the state did not do anything. So what public confidence would a victim of offense have if this is that? This is the first circumstances. Now Lordship will come to the next circumstances which has prompted us to file this petition. Kindly have a look at annexure A14, page 87. It is our case that the investigations have been extremely casual and again casual with a view to benefit the accused persons. Please have a look at annexure A14. This is the relevant. Lordship will appreciate that economic offenses are in a league of its own. Lordship will held in any time. These are all economic offenses. Economic offenses do not happen by the spur of the moment. These are cool, calculated minds who are at work. And in such offenses, electronic evidence is of extreme importance. Your laptop, your iPads, your communications, these are of extreme importance to corroborate the whole scene and to bring home the charge. Now kindly have a look at the Caesar memo. Can this Caesar memo stand scrutiny in any court of law? And see how casually it has been prepared. Page 87. These are all economic offenses. Lordship will have to see it through that prism. Page 87 is the Caesar memo, Ladyship. If Ladyship will kindly see how casually it has been prepared. 13. The following properties were packed and/or sealed, and the signature of the above witness were obtained thereon on the body of the property. Apple iPad with charger, one Apple iPhone red color. Lordship will appreciate neither model number is recorded, neither serial number is recorded. This is the state of investigation. Whether it's an iPhone 10, it's an iPhone 15, it's an iPhone 16. And even Apple iPad, what is the model? Nothing is recorded. And now see, even more serious is when the deposition of the Caesar witness is taken. See what he says. Please come to the next annexure, Lordships, which is at annexure, Lordships, annexure 15. Annexure 15, Lordships. Please come to page 91. That is this, and I will tell you, Lordships, once this happened in court, we were more than sure where the investigation is going, and that is why we have rushed to your court. When this happened, and this deposition is of 4th of April 2025. This is the Caesar witness. On oath, what he states, and see what he states in his cross. May I read the only? The above mentioned are my particulars. On the evening of 22/3/2024, police personnel from CID have seized one Apple iPad MacBook with charger from Zakir Habibur Hussain. As I was present at the place of occurrence at the time of seizure, I stood as one of the seizure witness and put my signature on the seizure memo. Exhibit P1 is the seizure memo in respect of Zakir Hussain's one iPad MacBook and 3 notebooks. Exhibit P1 is my signature. Exhibit M1 is the iPad MacBook with charger of Zakir Hussain. Lordship will appreciate the iPhone is not there. Now, Lordship will kindly come to the cross-examination. I am reading the cross. It is a fact that the date of seizure of Apple iPhone and Apple iPad with charger mentioned in my statement recorded by the case IO as a seizure witness is 22/4/2024. He confirms the date. It is a fact that there is no mentioning of the model number and color of the Apple iPad seized in the seizure memo. This is precisely, see how the accused is now taking the benefit of the casual investigation. And they are bound to take this benefit. Third, Lordships, I do not know the difference between iPad and MacBook. 4, it is a fact that a seizure memo exhibit P1, there is no mentioning of seizure of any MacBook. It is a fact that I do not know the essay produced today is iPad or MacBook, but it is the article seized in my presence. Now the last one, 7, it is a fact that one Apple iPhone red color as stated in the seizure memo exhibit P1 is not produced today by the prosecution for identification. May I ask why? Is this not going to help the accused? When this happened, of course, this is, I don't know whether I need to say it because we cannot say it in affidavit, but I took instructions from my client. It appears that the iPhone has got misplaced from the custody of the prosecution. This is what I have been told. So I'm just communicating. I'm not stating it or not, but the electronic evidence has got misplaced from the prosecution's custody. Now, Lordships, my third submission is this. We should have put that document on record, but for some reason we could not. I'm handing over, but we ensure we undertake to put this on record. Would Lordships kindly have a look? In fact, before I put this on record, Zakir Hussain is one of the prime accused, and there is another one gentleman called Dr. Madhurya Sharma. He is a big-time dealer of vehicles in Aizawl. Now, Madhurya Sharma is so well connected, Lordships, that he has not been, the state has never been able to take him into custody. Please see the modus operandi of this Mr. Sharma. Every time apparently Mr. Sharma the state seeks to take him into custody, he gets admitted into a hospital, gets a certificate, on the basis of which he spends that time in the hospital, that period is over, he gets released. Interestingly, Lordship, he is the owner of this hospital. Please have a look at these documents. See how they have taken advantage of the whole system. And the state has no problem. So we went up to the Supreme Court with respect to this man. And I'll show you the Supreme Court order, what Supreme Court has said. Now kindly have a look at that additional document volume, Lordships. Kindly have a look at page 4 of that page 4. In fact, it starts from page 1. This is the name of the hospital is Trinity Hospital. Every time he comes with a certificate of Trinity Hospital, which is in Aizawl. And please see at the first page itself, number 2, Dr. Madhurya Sharma, DMRD Radiology. He's a doctor. Then please come to page 4 of that compilation. Page 4, Lordship, at the top of the page, Madhurya Sharma, director. And page 21 of the same compilation, Lordships.
Page
21 of that same compilation, Lordships. Kindly have a look at the shareholding of this hospital. How they have compromised the whole system. Please see number 3 of that shareholding. Dr. Madhurya Sharma, so many shares, face values, this is the value. He takes a certificate from his own hospital, produces, the state has no problem. Never have the state said, why is he not being examined by a government hospital? That whether he is well or not. So, since he was successful in every stage, we went up to the Supreme Court. Supreme Court has issued notice. Lordship will come back to the and please come and look at the Supreme Court order, Annexure A9, page 66. This is the order of Supreme Court of SLP is pending, Lordships. Again, we had to go up. The state did not go up. May I just read the order? If Lordship will see the cause title, Mahindra and Mahindra Financial Services Limited versus State of Mizoram. It is submitted by the learned senior counsel for the petitioner complainant and respondent number 2, that is Madhurya Sharma. Accused has been involved in the economic offense amounting to about 150 crores. And though he was sought to be arrested, he was never taken into custody on the ground of his so-called illness. So therefore, the court has issued notice that what is this happening? And this is how it is happening. He produces the certificate from his own hospital and everything is fine, Lordship. Now, Lordship will see the third. Now, Lordship will kindly see, initially, of course, I had, when I started my submission, I had said, please make note of a name called Ankit Bagri. Now, this Mr. Bagri, at that point of time, he was based out of Aizawl or Calcutta. So, this Mr. Ankit Bagri was the overall in charge of our Aizawl operation. He was the overall in charge of our Aizawl operations. So, this Zakir Hussain and all were working under him. So initially, when the scam broke up, so the first complaint was filed by him. If you will also see that first complaint was filed by Ankit Bagri. But then we started our own investigations. So therefore, at that point of time, he represented the interest of the company at that point of time. Now what happened when we started our own internal investigations through our investigations, it came to light that he is one of the kingpins of it. It is under him that this whole thing was executed. This fact having come to our knowledge, we write to the Mizoram police and see what happened after that. Please come to Annexure A13.
Page 13.
Page 86 of my petition. We write to the Mizoram police. The date of the letter is 26th of June 2024. Please mark it, it has some significance. So immediately when we came to know, we informed the Mizoram police. And may I just read subject, request for change of authorized representative in FIR so and so. Respected sir, madam, Lordship may ignore the first paragraph. Please come to the second paragraph. As part of the investigations, our representative, Mr. Ankit Bagri, Chief Head and Branch Office at TBL Bhavan, Peter Street, Khatala, Aizawl, Mizoram, was authorized to liaise with the investigating authorities. However, due to his recent interrogation, on 25/4/2024 and subsequent termination of his duties on 25/6/2024, MMFSL finds it necessary to appoint a new authorized representative to facilitate the ongoing investigation as Mr. Ankit Bagri is under suspicion himself and he is not fit to represent the best interest of the company, which is the actual complainant and victim. And therefore, we appoint so-and-so. We indicated someone else. And this, if you see bottom of the page, this is received by the officer in charge on 3/7/2024. Despite this, now see what the prosecution does. Please take that additional volume against lordships. And kindly come to page 33. Ankit Bagri is now summoned by the prosecution as a prosecution witness. So a person who is accused of theft is now being summoned to prove the theft. And he is no more in our custody. I'm sorry, in our company. We have terminated him. Kindly see this summoning order. So what is the purpose? Purpose is to come and dilute the prosecution case. Naturally, now that he has been terminated and he is one of the persons under suspicion, it is expected that he will not support the prosecution case. And we have informed them. Please see page 33 of the additional volume. Have summons to Ankit Bagri. So we are actually at a loss. We just need that the people who are involved needs to be punished, and this recovery, these are public money. So these circumstances, one after another, which lordship I have pointed out, brings us to a definite reasonable apprehension. It is in fact not even a reasonable apprehension, it is more than reasonable. That the way the state is conducting itself, a lot needs to be desired. And if page 31, if lordship is see of that same additional compilation, this is the letter terminating Mr. Bagri. And see the reasons we have given. Para 2. It was reported that there have been multiple escalations which have received due by pertaining to the numbers not added up vis-a-vis cars sold by Nissan, Renault, and other dealers. It has also been observed that you have handled the aforementioned issues casually. Further, you have failed to detect the fraud which has resulted in huge financial liability to the company. So therefore, in this regard, suspension, we are terminating him. After this, you call him as a prosecution witness. He himself is an accused. If lordship will kindly see section 353 of the BNSS, an accused is a competent witness, no doubt about it. But that is for the defense, not for the prosecution. Finally, before my learned friend responds, I just place the principle that this has evolved, and this is a principle which has been laid down long time back. Just one judgment, lordships, of a 3-judge bench of the Supreme Court, that what needs to be seen. This is lordships. And before there's one more, there's one more issue that I need to just highlight before I read the judgment. And this is the ground. We have taken up this at para 17, page 10 of our petition. When initially we filed these complaints, the Mizoram government was quite proactive. They constituted an SIT. Considering the huge scam in the state of Mizoram, they constituted an SIT. SIT went ahead with its job. We were also satisfied that a good job is being done. Suddenly, for no reason, the SIT got disbanded. And it was reconstituted by new people. The old SIT had was collecting evidence against certain people. Now, these new people, new SIT that got constituted, has exonerated many of them. So the state needs to come clean before this court. But what is it that prompted them to change the SIT? Because the previous SIT was actually doing a good job. We concede. But the entire thing was changed. So these people, these car dealers are very well politically, very well connected. The media there is very hostile to us, Lordships. Unfortunately, I must say that. So these are also circumstances that are adding up to the fact that we are not in a position to really prosecute this case. Now, please kindly have a look at the judgment. Guru Sharan Das, this is a three-judge bench 1965 judgment, which the principle is still followed till today. And if Lordships was judgment, Lordships, kindly come to para 13 of the judgment. Page 347, para 13. I'll read from the middle of para 13. If has leadership got the law with regard to?
The law with regard to,
Yes, I'm reading from there.
yes.
I'll just read it slow. The law with regard to transfer of cases is well settled. A case is transferred if there is a reasonable apprehension on part of a party to a case that justice will not be done. A petitioner is not required to demonstrate that justice will inevitably fail. This is very important. He is entitled to a transfer if he shows circumstances from which it can be inferred that he entertains an apprehension and that it is reasonable in the circumstances alleged. It is one of the principles of administration of justice that justice should not only be done, but it should be seen to be done. However, a mere allegation that there is apprehension that justice will not be done in a given case does not suffice. The court has to further see whether the apprehension is reasonable or not. To judge of the reasonableness of the apprehension, the state of the mind of the person who entertains the apprehension is no doubt relevant, but that is not all. The apprehension must not only be entertained, but must appear to the court to be a reasonable apprehension. That is the test that Lordships will have to apply. And before just two inadvertent mistakes that crept into our petition, which kindly come to, if I may just draw your Lordship's attention to the relief clause at page 20. There are two reliefs we are seeking. First relief being
Yes.
the first relief being that these two cases need to be transferred to Guwahati and be tried here. Alternatively, if Lordships so feel that no, we may not transfer the case, then we are seeking a monitoring of the High Court. That the High Court monitors this case. Let it continue in Aizawl, but under the monitoring of the High Court. These are two reliefs. These are alternative reliefs. In these reliefs, there's just one inadvertent error that has crept up. If the first prayer, Lordships, we were seeking, if I may just read that, to transfer the proceedings in relation to FIR 96 of 2024 under section so and so, and FIR number 3 of 2024 under section so and so, pending before the Honorable Chief Judicial Magistrate Aizawl, Mizoram, the Honorable District and Sessions Court Aizawl, and the Honorable Guwahati High Court Aizawl bench, that has to be deleted. That's an inadvertent error, Lordships. I'm very sorry. It cannot be that we are seeking transfer from Aizawl to this. I'm sorry. That's an inadvertent. No, Lordship is deleting. So that we are not pressing. We are just seeking transfer of the matters pending before CJM and the Sessions Court. Similarly, the same inadvertent error crept into the other prayer also, Lordships. So I'm very sorry for that. If you Lordship will see, we are seeking monitoring. In fact, inadvertently, we said the principal bench should monitor the Aizawl bench also. So that is again, and the Honorable Guwahati High Court Aizawl bench. So that we are very sorry for that. That's an inadvertent error. We are not pressing it. So that may be deleted, Lordships. So having said so, I reserve my right to reply unless the AG wishes to file an affidavit to dispel this or whatever it is. Yeah.
Yes, Mr.
Proceed,
You want
Madam,
to file any affidavit in this?
madam. My lord, I'll come to that. I'll come to that, my lord. But first of all, I would most respectfully like to submit on the point of maintainability, my lord. Regarding the facts, I have heard, your lordship has also heard, and there are many misleading issues which have been raised, which is very unfortunate on the part of the complainant regarding a complaint which has been registered as an FIR at the very first instance, and already charge sheet has been submitted in both. I'll come to those facts later on. But on the point of maintainability, my lord, I would first of all like to submit that there's a bench at Aizawl. Guwahati High Court Aizawl bench is very much there. And at present, my lord, 3 honorable judges are stationed there. Even division bench is going on. I don't find the reason as to what prompted the petitioner to come all the way to Guwahati for transfer of this case. This matter, if at all the petitioner has grievance, this should have been raised before the Honorable Guwahati High Court Aizawl bench, which is the appropriate forum for which the Aizawl bench is stationed there. So my preliminary objection is,
I hope 1 minute. I understand your argument, but I hope lordship, the AG is not suggesting that lordship has no jurisdiction.
what I have suggested, my lord has well understood. That is not for you to tell. It is a fact, my lord, that the maintainability, it is not at all maintainable. That is my first leg of argument. That when there is a bench, there is a permanent bench there. And that is there because to facilitate the litigants to approach the High Court in respect of the same state. So I don't find the reason why they came all the way to Guwahati and have really, I don't find any reason. It's a wastage of the precious time of my lord, I would rather say. So on this point alone, my lord, this petition should be rejected. That is my first submission. Secondly, my lord, if your lordship kindly come to page 33.
30?
Page 33.
32.
33. Page 33 is, my lord. I'm sorry, ma'am. Page 34. This was the first complaint which was submitted by the petitioner company to the officer in charge of Aizawl police station. And my lord will see, it is dated 20th of March 2024. And the signatory is, authorized signatory is Ankit Bagri. Now, if my lord kindly allows me to go through it, we Mahindra and Mahindra Financial Services Limited, within brackets company, are a company incorporated under the Companies Act 1956, having so and so as registered its non-banking financial company NBFC with Reserve Bank of India and having its registered office at Gateway Building, Apollo Bandar, Mumbai, and corporate office at so and so place. Company is engaged inter alia in the business of advancing loan finance for the purpose of purchase of motor vehicles, SME finance, leasing of vehicles, etc. During our routine verification, we asked our area business manager, Jakir Habibur Hussain, mobile number so and so, who had sanctioned below mentioned loan accounts which were processed through his subordinates, namely so and so, extract of registration certificate of vehicles in question But to our surprise, all the PDF copies provided by Mr. Zakir Habibur Hussain shows same QR code with different number. So thereafter, my lord, I will take your lordship to the last paragraph of page number 34. We are apprehensive that these 9 cases, my lord will kindly mark this. We are apprehensive that these 9 cases are just the tip of the iceberg, and we apprehend that this is just a small part of a big pre-planned fraud committed by our above stated employee with the help of others to cause wrongful loss to the organization and to wrongful gain for themselves. We have started our in-house investigation on the overall live portfolio done under Zakir Habibur Hussain. There are more than 600 cases which have been done under him. We have come to know from the relevant sources that Mr. Zakir Habibur Hussain has come to know about the internal investigation which is happening against him and will try to flee. Now, my lord, on the basis of this particular complaint, Aizawl police station immediately on the very same day recorded and registered an FIR which is at page 31. On the very same day, my lord. My lord will kindly see page 31. Under section 408, 467, 468 and 34. Now thereafter your lordship will see that the state of Mizoram immediately, considering the importance of the case, constituted a special investigative team, SIT, to probe into the entire matter. And there had been prompt registration of the FIR as can be seen from the complaint and the FIR itself. I'll come to the authorized signatory part later on, my lord. My lord, thereafter several arrests were made. Total 24 persons were arrested. Seizures were done. Properties were freezed and statements were recorded promptly. No device or evidence that was seized as a part of the investigation is missing. And at present, my lord, there are 2 cases. One is case number 3 of 2024, which is for consideration of charge. And the other one is case number 96, for which the trial has already commenced. Each of the 2 cases, my lord, my lord, charge sheet and supplementary charge sheet has been submitted. In case number 96, my lord will kindly record it. In the main charge sheet, there are 73 witnesses. And in the same case, my lord, there was a supplementary charge sheet where there are 41 witnesses. In case number 3 of 2024, lordship, the charge sheet has been submitted and there are 66 witnesses. And in this, and in the supplementary charge sheet, there are 38 witnesses in this particular case. My lord, in the first case, the matter is pending for consideration of charge. That is in case number 96, case number 3 of 2024. And in the other case, trial has already commenced. 2 witnesses has already been examined and cross-examined. My lord will kindly appreciate the fact that the 24 accused persons were arrested. The first accused, Zakir Habibur Hussain, in whose name the FIR was first registered, was arrested on 13th of April 2024. My lord will kindly mark the date of the registration of the FIR. That was on 20th of March 2024. And the arrest was made on 13th April 2024. And as per my instructions, he is still in judicial custody. Pertaining to the other accused persons, my lord, accused number 2 in this serial which I have, Lalthan Kima, he was arrested in 13th April 2024 and he was released on bail on 16th May 2025. Same thing, my lord, for almost 23 other accused persons. They were all kept in custody either for 6 months or 1 year or 9 months, and subsequently under judicial orders they were granted bail. But charge sheet has been submitted, trial has commenced, and now they have come up with such a frivolous application, my lord, before your lordship's court. Now relating to the vehicles, my lord, there are almost 100 numbers of vehicles which have been seized by the police. Investigation has been done in an appropriate manner so that justice can be rendered in this particular case and the culprits can be brought to book. And in spite of that, my lord, I am really surprised to see this particular petition before your lordship for transfer of the case, which is not at all maintainable. Now, my lord, suppose, for the sake of argument, let us take into consideration that the matter is transferred from Aizawl to Guwahati. My lord, what will be the consequences? Well, there are so many witnesses. Your lordship has recorded my submissions. There are so many witnesses, and most of the witnesses, they stay in Aizawl. So they have to travel all the way from Aizawl to Guwahati, which will be a huge burden on the state's exchequer. That is number one. The accused who is in judicial custody has to be brought from the judicial custody at Aizawl to Guwahati for each of the hearing dates. There will be multiple court appearances which will involve the police personals to travel all the way from Guwahati to Aizawl, from Aizawl to Guwahati. And moreover, my lord, in such an important case where the police and the investigating agency had done a perfect job, very efficiently, very sincerely, it will just break their morale. Now, coming to the point of Ankit Bagri, which had been raised by my learned friend also during his submission, that why he has been named as a prosecution witness. My lord, he was the complainant. On the basis of his complaint, FIR was registered. He was very well part and parcel of this company. What the petitioner is afraid of? Does the petitioner think that Pandora's box will open if this person is named as a prosecution witness? The fraud to the tune of more than 150 to 200 crores went on for years together. And the top bosses of the company, the management of the company, was not aware of this fraud. Audit was going on. Yearly audit was being conducted. And the auditors could not trace this particular fraud. It went unnoticed, both to the management and to the auditors. Is it believable, my lord? And now since the complainant, under whose complaint this particular case has been registered, he cannot be placed as a witness. Why? Many things may come out. We want the truth to come. Let the truth come out. Why they are objecting? So my humble prayer, my lord, at this stage, my lord, it will be a miscarriage of justice if this petition is entertained. And my humble prayer before your lordship that this petition for transfer may be rejected. That's all, my lord. Well done. बोलून नको का आपने?
Yes, any more reply?
Yes. Lordship will kindly
Make
come.
some short submission. No? Yeah.
I'll just take a short submission. I don't need to reply because kindly come to section 447 of the PNSS. Good Lordship, sir. 47.
447.
Provision under which this petition has been filed.
Yes.
Power of High Court to transfer cases and appeals.
Hmm.
Whenever it is made to appear to the High Court, that, please see the use of the words, that a fair and impartial inquiry or trial cannot be had in any criminal court subordinate thereto, or that some question of unusual difficulty is likely to arise, or that an order under this section is required by any provision of the Sanhita, or will tend to the general convenience of the parties or witness, or is expedient for the ends of justice. We are stressing on 447 1A and the last expression, all is expedient for the ends of justice. The learned AG appears to have said that there will be inconvenience, there will be witness movement. Lordships, can justice be compromised for the sake of convenience? Please see that a fair and impartial inquiry or trial can general inconvenience of witnesses traveling or the accused traveling be put at a higher pedestal? And for that matter, my learned friend is now appearing from Calcutta. VC is available across technology. Adopt technology. You don't need to travel unless absolutely necessary. So therefore, this argument can never lie in the mouth. That justice has to give way to convenience. Please appreciate, lordships. Is it fun for us to come and approach your lordships for transfer? Until things were done in a proper manner at Mizoram, we were totally okay with it. But today, when we see that there is a sustained effort to cover up tracks, sustained effort to dilute the case, it is then that we are coming to your lordships. Ultimately, we are the victim. Please appreciate it. Who is the victim? We are the victim. So what has prompted us? It is not a exercise in futility, as my friend would like to put it. And as regards maintainability, lordships, there is one aspect of the matter that I thought I should not tell earlier. I did not comment on it. But unfortunately, certain proceedings of ours, certain proceedings which happened in the trial court and the sessions court, we had to go up to the High Court challenging certain orders. Well, we can give you those orders if lordship wants, but for some reason or the other, there has been a recusal because maybe it's a small state, lordships knows one party or the other. That was one issue that we were also faced with. Because lordship will know that it's small tribal community, so one would be knowing. So it was a fairness of the bench that they said we would not take up this matter. Not this particular case. It is not that we approached the Aizawl bench, but the earlier proceedings. That is one aspect of the matter. And secondly, lordships, ultimately substantial justice has to be done. Maintainability and all, these are all technical issues. If lordships today seeking, yes, these people are being denied justice, nothing prevents this court to exercise its powers. It is not a case that lordship doesn't have jurisdiction. It could be a concurrent jurisdiction. As we see in anticipatory bails, it could be a concurrent jurisdiction. But that doesn't mean lordships has no jurisdiction. We have come before a court that has no jurisdiction. So having seen everything, it is my humble prayer that lordships may transfer this case to the competent courts and do just and let it commence from the stage, because traveling of witnesses and all this, these are not even considerations when justice is ultimately, it is justice that has to be not to be only done, but has to be seen to be done. That is the expression the Honorable Apex Court has said. I am so very grateful, lordships. I'm extremely grateful for that.
Heard Mr. M. Goswami, the learned senior advocate, assisted by Rana Singha. And you also assisting?
Yes.
Your good name? Amay?
Miraj.
Miraj?
Miraj.
Miraj Kliba. लिख दियो बस. Also heard Mr. B. Dev, the Advocate General Mizoram, assisted by MS P. Bhattacharya, the additional AG Mizoram. Order to resign. Okay, we'll pass the order. Order is reserved.
All right.
Flagman.
Okay, Mr.
Item number 5.
No,
Your Lordship. Yeah, name to cancel
Ladyship, Mr. Mirajka's name may not be recorded.
He has not signed the wakalatnama.
okay then, okay.
Aman
Okay.
Mirajka's name.
Sure.
May not.
It will never go on. Okay then, okay.
May it please your lordship. Lordship, this is for Jima of the cash and the iPhone that has been seized by the police in connection with Tinshukia PS case number 122 of 2024. Under section 120B 406 420 read with section 13 and 14 of the Assam Game and Betting Act 1971. The cash which they have seized, my lord, that has been accounted for, my lord, and I have given the detail in my petition, my lord, that your lordship will find in page 6, paragraph 4, my lord.
My lord, here in this case, my lord, the report was called for, my lord, but that is not received, my lord.
But the thing is, your lordship, the FIR is of April 19, 2024, my lord. Until that, they have not done anything, my lord, and that much time, more than 1 year, my lord, for investigations. And if your lordship will see the rejection order which the learned court below has passed, my lord, when we have filed the Jima, that if your lordship will kindly come to the operative portion and
What is the, actually what you are submitting? I have not heard you. In fact, this is the Jima petition.
Jima petition, my lord, for cash and
So
one
what-
iPhone,
What
my
was
lord.
the order, last order? You
Last
did a
order, my
report?
report was called for from the IO, my lord. And
Yes,
we
the fourth
we
time.
have, my lord, communicated, my lord, but my lord, report not received today, my lord. Kindly have a, my lord, date, my lord, on, kindly fix on, my lord, 25/6, my lord.
That may be the last chance, my lord. This is the 4th time they
My
are
lord.
saying.
We will-
Because, and matter is of 2024, my lord. In April only, they have seized my money, my lord. And that has been accounted. I have submitted all the documents, my lord. And my
So where is
iPhone-
the rejection order? Rejection order?
Rejection order operative portion is at 103, my lord, page 103, if your lordship will kindly come to 103. Prayer for Jimma mobile phone, my lord. And mobile
So
phone-
you're seeking Jimma for one mobile phone?
mobile phone as well as the cash. It's
Cash,
the-
what was the amount?
Amount is 62,000, 62 lakhs, 80,890, my lord. And that operative portion is at page 109, paragraph 2. Prayer for custody of seized case, amount in petition number so and so. And everything has been accounted for, my lord. All the documents were supported to them. And the petitioner is a proprietor of this one Ganpati Plastic Emporium in Tinsukia, my lord.
One twenty B 406 420.
Games and
Read with games and betting.
Yes. And this is the fourth time, I know, that's why I'm pressing for it.
So you communicate with the IO personally,
Fine.
because definitely it is the fourth time.
Fine.
It's not receiving, we have not received. Hard MS, your MS?
JM Convert. JM Convert.
JM
Convert. JONWR.
JM Paul, the learned counsel for the petition, also heard Mr. B. Sharma, the learned. You are here, you are appearing any special or PP as a PP?
PP, ma'am.
Additional
Additional PP.
Additional PP, so it's. It is submitted by Mr. Sharma that though they have already intimated or signal has been sent for submitting the report from the IO, but that has not been yet, it is not yet received. And accordingly, paid one more chance. Communicate the IO in regards to that. No, communicate the IO. MS Horn, they submitted in this record that it is the fourth time wherein the prosecution failed to produce the report, and accordingly it is submitted that the last chance may be given to the prosecution for the report. In view of this, the learned additional PP is hereby asked to take all endeavor to procure the report from the IO on or before the next date of listing. List accordingly, you are saying that it should be listed on 25/6?
My lord.
List on 25/6. Okay, we are listing.
Obliged.
And 6. There is also, my lord, same prayer, my lord, kindly. My lord, we have not received report from IO, my lord. This is, my lord, vehicle of Jimma, my lord, one Mahindra Xylo.
Cases registered under which section?
This is.
It's NDPS matters?
No.
No, my lord.
The case is registered under my lord, your lordship will find that page my lord 10 my lord. Page 10 is the FIR. This is registered under section 3032, 3172, 112. NSS and they will section 7 of the EC Act, my lord, Essential Commodities Act. My lord, here, my lord, what my submission will be, my lord. My lord, in fact, the report in your lordship may kindly produce the earlier order of the my lord, the learned court below, page 14, my lord. There, the report, my lord, it is not that, my lord. Only that order was rejected, that my lord, on 7/4/2025. By this order, the Jimma was rejected by that, my lord. I was not the Jimma petitioner in that case, my lord, because the owner of the vehicle, he did not appear. Only for that reason, my lord, the Jimma petition was rejected on 7/4/2025.
It was not filed by the owner.
Yes, it was not.
So
Later,
now
my
this
lord-
time you are the owner.
Yes, madam. Later on, I filed the my lord, petition that has been rejected on your legal issue, my lord. My lord, your lordship, page 16, my lord, 34/2005, 2025. That is the order. Otherwise, my lord, there is no impediment because the learned EPP, if your lordship will find page 16, my lord. In the third para, and the my lord, Bodiur Zaman with a prayer to grant Jimma. Copy of the registration certificate of the said, your lordship will find last part, man. The learned PP submitted that a court may pass order as per law, man. because there was no objection at all, whatever. The court has gone through. It appears that earlier report was called from the police regarding the said vehicle white which was accordingly received, but petitioner did not turn up and furnish documents of the vehicle diesel as directed. Accordingly, prayer was rejected because the documents were not submitted. The prayer was rejected. Now the court has present by this order, my lord, the Honorable Supreme Court in so and so stated that in so and so, due to this case only, this observation is, my lord, the learned court below has rejected my case. But this is defined, my lord. This
Then one more chance may be given, otherwise.
Earlier occasion on 26/5, my lord, you are not put as for my lord, for a report. my lord.
A report was called for, definitely.
Yes.
So what is your position now, when it can be fixed? Before vacation, may not be possible also, I don't know.
20, it's basically nearby. It's not
No,
immediate.
nearby, question of nearby is not
26
there,
month.
but
26 or 27?
27, because
27/6.
My lord.
26th month. On 26th of this month.
My lord,
I don't know, 26 or 27, Mr. Sharma.
27 last day.
Heard Mr. J. Pine, the learned counsel for the petitioner, also heard Mr. B. Sharma, the learned additional PP, appearing on behalf of state respondent. Next, it is submitted by Mr. Sharma that report is not yet received from the IO, and accordingly he is submitted that one more chance may be given for the same. Considering the submission made by Mr. Sharma, the learned additional PP, let the matter be listed accordingly 27/6/2025 with a direction to the prosecution to the learned additional PP to call for the report. And IO is also hereby directed to furnish the same on or before the next date of posting. Okay.
This honorable court has clarified that if there is no process of
Confiscation.
then it will be released.
Made your lordship, man. But this is a page, your lordship will find page 22.
Page 22.
Page 22. FIR is dated, my lord, 19. 23/12/19, my lord. FIR. And FIR is, my lord, that 2% the present petition was minor at that very point of time. And both of them have some relation, my lord. Some photos were exchanged. And thereafter, my lord, the charge sheet was filed on 31st October 21. 31st October 21, page 31. Initially, case was registered, your lordship will find under section 2, that section including section 67 of the IP Act. So now charge sheet, my lord, the IP Act already gone. It is not there, only, my lord, IPC is there, my lord, the charge sheet. And all sections are available, my lord. Now I have come only, my lord, just your lordship, I see only one paragraph, my lord, from my petition. Your lordship, kindly have a look to page 6.
So now your charge sheet is under which section?
Now under charge sheet is under section, my lord, 8, 294.
294 and 509.
Yes, 294, 385, 509, 350, 4D.
D.
Stocking. 394, my lord, 294, that is, my lord, obscene, 3 months only, punishment, 509, 3 years, my lord, that is the intent to insult the modesty of so and so, and 354D, my lord, stalking, that also first conviction, 3 years, second, 5 years, 67, IT was there, but it is no longer, it remains, my lord. Now, my case is, my lord, only just have a look to 145 lines, my lord. You'll also can see page 6, you'll look at this one. Police matter 41 notice, we have responded, I have gone there, madam, along with the paternal uncle of the victim. Now, page 6, your lordship, I am only on that at river. The petitioner, along with his uncle, went to the police station at about 7 p.m. After a few minutes, the informant also came with her paternal uncle. After some discussion, it was found out that there was some misunderstanding between them, and as such, the matter was amicably settled, and both the sides requested the officer not to proceed further in connection with the said FIR. The officer asked both of them not to keep contact with each other in future. The petitioner was allowed to go on his uncle's bail, madam. So now matter will be settled. That's why I have come before Lordship. Your Lordship kindly issue notice to the private respondent, let them come, and I think my matter will be settled here. This is only my prayer for prayer.
But the private respondent is not the petitioner here.
No.
It is
I
it's a
have
joint
come-
petition.
Yes, I made the respondent, but
Made party, my lord.
party.
Party.
So Dosti Sarvi, I have been told by somebody is here, a relation, they might have engaged also, my lord. Someone, my lord. So if Dosti Service, if Lordship allows, my lord, we'll take it within
No,
2
no,
days.
Dusty will not be allowed.
Or both your Lordship can be, my
Maybe through jurisdiction police station, that can be done.
lord.
Jurisdiction police station can be.
Yes. And in the meantime, if they appear, no problem, my lord. Suppose if they get the information, they may appear also, my lord. So that will do. In the meantime, my lord, no coercive action may be taken. It is already status appearance stage, my lord.
Appearance stage.
Appearance.
But your petitioner was otherwise on bail, no?
Yes.
You were shown as an absconder or?
On bail, yes, police, but at that time, I was on bail, my lord.
No, in the charge sheet you were shown as an absconder?
No.
No.
I appeared, my lord. Only because I am saying because ultimately process will go on, proceedings will continue. my lord.
Now, why you need the
That
coercive
proceedings,
action?
but a proceeding may not go further, my lord. That is why I am on, my lord.
So
Once
you on
matter
the
will end.
other way you have submitted. No coercive action section shall be taken.
No, my proceedings, ultimately court has already given, date is fixed, my lord, for my appearance. So once I am to appear, my lord, naturally, my lord, there is no need, if matter is settled, there is no need of further proceedings, my lord.
But at this stage, my lord, there will be no coercive action, my lord. Because he is on bail and.
No, I am not saying on that line, my lord, because he is on bail, my lord. My language may be otherwise, my lord. It should be, proceedings should not go further. That is my case. In pursuance of the charge sheet, my lord.
Heard Mr. H.I. Chaudhary, the learned senior advocate, assisted by Mr.
Yes,
S.S.
yes, Ahmad.
Ahmed, S.S. Ahmed, the counsel for the petition. And also heard Mr. B. Sharma, the learned additional PP, appearing on behalf of state respondent. Even listening at how long issue notice for to respondent number 2 to registered AD. No, registered AD, no, registered AD, दिया जाए नहीं कहीं through jurisdictional police station. It's not, the petitioner will take steps within 2-3 days. Further, considering the submission made by learned senior advocate, Mr. Chaudhary, in regards to compromise of the matter between the parties. Further proceeding in case number.
In case number, my lord, it should be.
It is pending before
Yes,
JMFC. JMFC.
PRC case number 254.
PRC case number
256 of 24.
2024.
Arising out of Jamunamok PS case number.
Arising out of Yamunamok PS case number 163 of the 2019.
Yes.
Pending before the learned
JMFC Magistrate, first class number 5.
FC number
At
5,
Hojai.
Sankadev Nagar, Hojai, P state, till returnable date. List accordingly after 4 weeks. Okay.
Obliged.
Should we call for the scan copies?
Yes.
Scan copies, okay, so call for redistribute duty need.
Item 8.
May please, your lordship.
Please.
Hello, this is a petition number 528.
528
for quashing, my lord.
Yes, yes.
Well, look, here the case is almost a peculiar matter, my lord. The case was the check under, because quashing of 138 proceeding, entire proceeding, my lord.
NI.
NI.
Hmm.
The check was lost on, my lord, 23/9/22. The lordship may record that date, my lord. 23/9/22, the check was lost, my lord. I have lost the.
Your check was lost.
Lost. Number of checks and some blank papers. So I have lost the FIR on 23/9/22. On 15/11/22, I informed the bank also that these are the check numbers which are lost. Now, thereafter, my lord, the petitioner by this letter, he deposit the check before the bank
complainant has deposited the check on the bank on, my lord, 14th of April, 25, 23, 14th April 23. After
14th
the
of
lapse of,
April.
yes, after the lapse of 6 or 7 months. And bank has stopped the payment on the ground of stop payment. That your lordship will find page 38, para 7 minute. And bank has intimated me through that letter that such check has been deposited, we have stopped the payment. Your lordship find it there. Page 38, lordship, last one. That the account balance at that is stop payment, the payment was NRI so and so and the stop payment, except the date, and that was 15/11/2002, which 15/11/2002 that I informed the bank. And in respect of that, bank has intimated that this check has been deposited, now it has been stopped. Now, under 138, it is a settled by the Apex Court that only on the 2 grounds that offense can be taken. One is insufficient fund and second is exit payment. Otherwise not. Now here is the case, my lord, where I have informed the office and bank that such and such date my check was missing, lost an FIR. On the basis of that, where the magistrate has ought to have taken the cognizance, he has to look into all the materials. Your lordship will come to the complaint petition, page 4.
Page?
Page 22. The portion, how they have drafted the complaint petition, suppressing the fact that I have replied in the notice that the check was stolen. That I have informed him in his reply to the 138 notice. That he has not stated in this paragraph. That's all will come. Page 22.
But notice was served on you under 138.
Yes, and reply I have given. In the reply, I have stated that these are the checks which have been stolen. He has the information that this is a stolen check, which I have lost it in the FIR. I have stated that is a lost check. Now your lordship will come. That your lordship will come to page 22, para 10. That the accused person received the said notice on 2/5/23 and instead of making payment check amount, accused through his advocate sent one reply notice with some vague and baseless allegations. He did not say that we have stated in the notice that it was a lost check. Your lordship will see the notice which we have given the reply. That is, the lordship, page 33. Page 33, my lord, first, second, third, fourth line. Page 33. That is the reply of my case. That yes. My aforesaid client informed me that the aforesaid checks, along with the 3 number of blank non-judicial stamp paper and 3 number of blank non-judicial stamp papers of 20 rupees, another 3 number of bank non-stamp paper of 100 with A4 size paper, but aforesaid non-judicial paper, A4 size bank paper, and aforesaid checks where his lost non-judicial paper. I have stated in my reply, which was the part of the record in the complaint case. But the learned magistrate, before taking the cognizance under 138, ought to have gone through these letters to find out whether the intelligence of 138 is there or not. But the court did not go into this letter, because if the court has gone into this letter, then naturally they would have asked for a police report. Where is what happened to this lost check? On that ground, my lord, I just rely on one decision you will go through. Because I have come for that, no cognizance at all in the lost check. Your lordship will come to the my lord, para 10 onwards, my lord. The legal section. The legal fraction created under 138 NI Act, that is para 8, my lord. Your lordship got it.
Para 8.
8.
Yes.
The legal fraction created under 138 of the Act when the check is returned by the bank unpaid has been explained in the para 10 as follows. A bare perusal of the aforesaid provisions would clearly go to show that by reason thereof, a legal friction has been created. A legal friction is well known, though it's required to give a full effect, has its own limitation. It cannot be taken recourse to for any other purpose other than one mentioned in the statute itself. In the state of Andhra Pradesh versus so and so, in other words, all the consequence ordinarily flowing from the rules would give effect if otherwise does not limit the operation thereof. If the rule itself provides a limitation on the operation on the consequence flowing from the legal fraction have to be understood in the light of the limitation prescribed. Thus, it is not possible to constitute the legal fraction as registered by the, as suggested by Mr. Loli. Under section 138 of the Act, moreover, provided for penal provision. A penal provision is created for created by the reason of the legal fraction must receive the strict construction. These are the decisions given. Such provisions enacted in terms of the legal fraction would draw and attract the check in return by the bank unpaid. Such non-payment may be either because of the amount standing in the credit, that amount is insufficient to honor the check, or it exceeds the amount arranged to be paid. Before proceeding thereof, initiating a legal requirement, there must be complied with. The court must be satisfied that all the indigence commissions of the offence under said provision has been complied with. The parameter of invoking 138 of the NI Act thus being limited, we are of the opinion the refusal on the part of the bank to honor the check would not bring the matter within the mischievous provision of 138 of the NI Act. Then the court has given, my lord, the apex court judgment also, my lord, where it is said in the para 7, my lord, that apex court also said that if these two indigents are there, then it will be covered under 138, otherwise not. No, my lord, lordship will come. From para 6, according to the section 138 of the NI Act, where any check drawn by a person on the account maintained by him with the banker for payment for any amount of money or another person from or out of the amount for discharge of whole or part of the debt, other liabilities returned by the bank unpaid, either because of the amount of the money standing on the credit on that account is insufficient to honor the check, or that it exceeds the amount arranged to be paid from the account by an agreement made with the bank. Such person shall deemed to be committed an offence under 138 of the NI Act. The check has to be presented within the statutory period in which it has drawn to be within its validity. Secondly, the payee or holder in the due course of the check makes the demand for the payment of the said amount of the check by giving notice in writing to the drawer of the check within the statutory period on the receipt of the information from the bank regarding the return of the check. Therefore, if the check is dishonored for the reason because the amount standing to the credit of that account is insufficient to honor the check, or it exceeds the amount paid, that amount by an arrangement. The position is different. Now,
Okay, then I have understood.
Yes, your lordship got it. So at this stage, I pray, my lord, let the notice be issued and further proceeding may be.
Mr. K. Mr. K. Bhattacharya, the learned counsel for the petition. And also heard Mr.
You're just formal party, I think.
Yeah. So heard Mr. B. Sharma, the learned PP, appearing on behalf of State Principal number 1. Okay, this is an application under section so and so in connection with so and so for washing and all. He said that we fill up the cost item. Issue notice to the respondent number 2 to register DD and as usual process. Also call for the scan copy of the LCR. Next, further it is submitted by Mr. Bhattacharya that the present accused present case is peculiar in nature, wherein the present petitioner had lost some checks along with some stamp papers and other documents, and on the basis of which he lodged an FIR on 23/9/2022, and the bank was also informed accordingly about the loss of check on 15/11/2022. But thereafter, the complainant had deposited the said check in the bank on 14/4/2024, wherein the court stopped the payment and informed the present petitioner in regards to deposit of the check in this bank. Further, it is submitted that the suppressing all these materials which he had reflected in the reply to the notice received from the complainant of the respondent number 2, the court had taken cognizance without considering those aspects of the case. First. Mr. Bhattacharya further submitted that the case under section 138 an act can be registered or can be taken cognizance in on two grounds, wherein there is if there is account is insufficient to honor the check, or that it exceeds the amount arranged to be paid from that account by an agreement made with that bank. But here in the instant case, without complying this provision, the cognizance has been taken by the learned trial court below. Accordingly, Mr. Bhattacharya paid for the stay of the further proceeding in given number case number 21, so and so. In that context, Mr. Bhattacharya also relied on a decision of Honorable Supreme Court. No, sorry. It is a High Court.
It's a High Court, but
High Court of Kerala. No?
Kerala.
Decision of Honorable High Court of Kerala. Passed in Criminal Division Petition number 2016 of 2003, dated 9/6/2015. Next paragraph, considering the interest submission made by Mr. Bhattacharya, let the further proceeding in NI case number 3597/2023, pending before the learned CGM Kamrup M, be stayed till returnable date. List the matter accordingly after 4 weeks.
Yes. So this application, Malad, for custody of vehicle, Malad, also says by the Malad Bagbor police in connection with one accident case, Malad. FIR is Malad page 13. May I read, Malad?
Just a second, have you approached the
Yes.
trial court below earlier? Is there any rejection order?
No, my lord. In this case, what happened, my lord? Page 4, paragraph 4 of my petition, my lord. I'd like to read out this paragraph, my lord. Actually, my lord, that the petitioner beg to state that though IO detained the vehicle on 24/25 from the custody of the registered owner, but till date not provided any seizure memo to the registered owner. On the other hand, before filing this instant application, the petitioner tried to collect the certified copy of seizure list from the court. But after gone through the records of the case by his engaged counsel, the petitioner not found any seizure list in the record. As such, the petitioner unable to annex with the seizure list. Now, my lord, paragraph 8 of my petition. Page 6, my lord. The petitioner beg to state that in many occasions, at first he has approached before the IO to allow the custody of the instant vehicle, but the IO has denied every time. The petitioner filed petition under section 528/442 of the BNSS
before the learned court below to allow the custody of the petitioner's vehicle, but said petition was not admitted, my lord, by the learned court below on the ground of there is no seizure list. Police since the 20 April, my lord, my vehicle was detained by the police and which is laying within the premises.
So where is the order that is not admitted?
My petition was not admitted, no any order passed by the learned court below. My petition, petition.
Whether your
Not-
petition is still lying in the record?
No, no, no.
Where is the petition?
Not accepted, not accepted by the.
Then that is still not a petition. Where is the petition now?
My
You
lord,
have filed the petition.
This petition that petition I have not annexed here with my lord, but
No. This petition is still in the record, I think. Where no order was passed by the learned magistrate.
no.
Then where is the petition?
Petition not accepted by the court master itself, my lord. Without seizure list, we are.
So you could have bring all these things that the
Hello.
seizure list is not there and all. Whether seizure list is still not there.
It's
in
still
the-
not there, my lord.
Huh?
It's still not there.
It's still under
Yes,
under the
before filing
investigation
this
phase.
application, before filing this application, we have check
So
the.
it is not our duty to call for all these seizure list and all. Where from? We'll get.
But my vehicle is laying in the within the premises of the police station. I have annexed photo.
You approach the learned trial court below. That's what I'm saying, because there a record is available there.
But-
There will be the occasion for perusal of the, and you bring all those things
Yes,
before
yes.
the learned trial court below that seizure list was not provided to you. There was no seizure list at all.
My
Those
lord.
things can be.
I understood the same, my lord, but accordingly, I have approved before the court below, but my petition not entertained, my lord, by the court below. Any no order has
But you
been
have
passed by.
filed anything here.
No order has been passed by that court, my lord. Which document I have, I can annex with this.
You're saying
petition.
that on one hand it's a case of accident, then definitely seizure list will be there.
Vehicle is not seized till with, my lord. Before filing this application, we are check the record of the court.
Then you do one thing, place all this before the learned trial court below, that vehicle number so and so met with an accident. And it is still, the seizure list has not been prepared, so we do not know what is the stage of the, what state the vehicle is kept in the police station. So he may call for a report from the concerned police station regarding the status of the vehicle.
By
That can be done.
My lord, by stating everything, my lord, whatever directed by this honorable court right now, my lord, I have placed submitted the.
But your
application,
petition, it cannot be entertained now. What can be entertained?
my lord. But
There's
Lord,
no
Lord,
order, rejection order is not there. You have no, your
Lord, but
petition is
also on
not
the same
entertained.
ground.
Then
Lord,
how can it be entertained? It can be entertained now.
Lord,
Because it is not duty of the High Court to call for all the reports and all.
my lord.
That's what I'm saying, that you can file a petition before the learned trial court below,
My,
seeking, because what is the stage of investigation, what is the state of the vehicle, where the vehicle is kept, those materials can be bring. So he may, the learned trial court may direct the police station or the police authority to give the detailed report in regards to the vehicle, but otherwise how can we beat him, because it is not before us that your vehicle is been seized.
my lord.
Tomorrow, if some report has come, suppose, then definitely police will tell, we have not seized any vehicle. Then what will be the position? We are not in a position to inquire the
Would-
matter now.
Which such type of direction, my lord, my petition at this time may be disposed of. I will approach before the learned court below. Earlier, I have, though I have approached, but not entertained by the learned court below.
Okay.
Everything I have stated in my petition.
Oh.
That
Heard
observation may be
Mr.
given, my
A. K.
lord.
Azad, the learned counsel for the petitioner, and also heard Mr. B. Sharma, the learned additional PP appearing on behalf of state respondent. This is an application, the section so and so in connection with so and so liquidative. It is submitted by Mr. Azad that his vehicle was seized in connection with which case? This one, this case only.
Bagbor PS case number, my lord.
Bagbor.
Bagbor PS.
Bagbor PS case number 24. 24 of
24, okay,
2025 under section 281, 125 subsection small b, BNS 2023. But he could not collect the certified copy of the seizure list, etc., as no seizure list has been prepared by the IO, and his vehicle is not shown to be seized by police in connection with this case. Mr. Azad further submitted that he also approached the learned trial court below with a similar kind of petition seeking jima of the vehicle, but his petition was not entertained by the learned trial court below, as he could not furnish the seizure list along with the jima petition. In view of this, the petitioner is hereby directed to approach the learned trial court below
with an appropriate application to seek for paying for paying for intimation in regards to the status of the case as well as the state of the present status of the vehicle as to whether it has been seized in connection with this case or not. However, the present petition cannot be entertained by this court at this stage. The full petition is disposed of accordingly with above direction.
Supplementary item number 26.
Direction might be given to the
Yes.
lower court. my lord.
Yes, I have already given direction that you can approach with an appropriate application before the land trial court below. It can.
Without,
Direction is given.
without Caesar list, if I am,
No, without Caesar list, regarding the status of the case, how the learned trial court below is also not in a position to entertain your case. How it will be entertained? Because these are so that the court below can ask the police authority in regards to the status of the case as well as the status of the vehicle, whether it has been seized or not. The report will come definitely from the IO.
Master.
Is Kiman, please question?
Supplementary 26.
Supplementary.
May I please, Your Lordship?
Yes.
Lordship, here, since this matter has come up before Lordship for the first time, I'd like to apprise your Lordship regarding the fact of this case. Now, what has happened, Lordship may kindly see. Here, I am praying for quashment of the order of taking cognizance and the charge sheet. Who are the petitioner? There are 3 accused persons. I am also one of them. Now, here, what has happened, this petitioner is a contractor, Lordship. And he is a class 1 contractor, and till date, there is no any embellishment against him. Absolutely no complaint against him. Now, a tender was floated, Lordship will kindly see. A tender was floated for the purpose of construction of Jayantia Road under the State Disasters Relief Fund for repairing a stretch of road for 1.66 kilometers. And for the said purpose, a
So
contract.
it was, why it is in motion call, in fact? The
Because-
order was, detailed
because
order has
Lordship,
been passed by
there was an order
the court
passed
and
by-
bench.
For
Yes.
the purpose of considering the interim order, the scan copy of the CD and the scan copy of the LCR was called for today.
You cannot hear now.
CD
Scan
and
copy you have received, Mr. Sharma.
scan copy.
My lord. Scan copy not, no, it is not reflected in the cost list, man. Generally, my lord, scan copy when received.
It is in
reflected.
the order. I have the order. I can share the order with your Lordship. Sure.
No, order, no, what order?
Order of the court.
Order of
Previous-
this court?
Yes,
No,
Lordship.
this court is available here.
Yes. So your
No,
Lordship.
regarding the scan copy, I'm saying. Scan copy you have not here, it's not here, no?
Lordship,
Not here.
if I just read out the last part, I
Ah.
have considered the submission at the bar with circumspection. It appears that to consider the prayer for the interim stay, the trial court records are necessary. Call
Yeah.
for the scan copies of the trial court records along with the scan copies of the case diary. List this matter again on 18/6/25. This was the order.
This scan
This
copy
is
not
the
received.
order. But copy is not here. That is the case.
Lordship may then again call for the scan copy and
Yeah, we have to-
direct a registry to take the.
Otherwise case is charged at one.
Yes,
Yes,
yes. Cognizance also taken, and I am absolutely on the cognizance that has been taken, Lordship. Pepsi Food is very clear. The cognizance has been taken absolutely mechanically. There's nothing, absolutely nothing is there. So Lordship may kindly call for the.
So
scan-
we can do one thing, I think so. Because if the scan copy is, if there is a necessity of the scan copy to
That is the
see
reflection of the
that-
order, Lordship.
yes,
if you go by
obviously,
it.
obviously. So in that case, if the scan copy, we receive the scan copy on the next day, it may be matter, maybe I think heard and disposed of also. I think so.
That I leave it up to your Lordship.
No, we'll see to it, because if the
Absolutely.
matter is, if the scan copy we receive before passing the order,
What is- Just in presence of my brother, I'm just saying the crux of this case. Lordship, the charge sheet has been filed after 9 years. FIR has been lost after 2 years. 9 years they investigated, there is nothing in the charge sheet. And Lordship knows about 173, that their nature of offense has to be mentioned. They are writing prima facie case.
Do you approach, have you approached the learned trial court below
No,
with
Lordship.
173 also?
No, Lordship, no, I have not. I've come straight for this honorable court because I should not be dragged into a long drawn legal battle. 9 years, after 9 years, they are filing charge sheet. Now, if I appear there before the court below, it will take away another 10 years or we don't know. And absolutely, there is nothing against me. Absolutely nothing against me. My entire career will be spoiled. If your Lordship just look for a moment of time, they are saying embezzlement of the money. I will show you, Lordship, only one document, page number 21, Lordship. And if your number, that is the completion certificate. FIR is saying the embezzlement of money. Lordship, kindly see, payment already made, 0. Not a single payment has been made to me. How come I have embezzled the money? Absolutely a perfunctory investigation. Money was 42,89,544 and the payment already made is 0. And I have completed the work with all satisfaction. And after 9 years, they have charge sheeted me, they have charge sheeted the engineer, they have charge sheeted the junior engineer, only because DC after 2 years does not find any topping in the floor. After 2 years, there are so many floods, so many rain. He should have done immediately. Why after 2 years he is going for inspection when I have asked for the money? So this is the case altogether.
Oh, heard Mr. A. Patachari, the learned counsel for the petition. And also heard Mr. B. Sharma, the learned additional PP, appearing on behalf of state.
Lordship, I kindly issue notice upon respondent number 2, Lordship. That has not been done, Lordship.
From the record, it reveals that by order dated 10/06/2025, a scanned copy of the case report was called for as it was considered necessary to consider the interim prayer for stay. However, it is submitted by Mr. Sharma that the scanned copy of the case report along with the case diary is not yet received by the registry. Full stop. Issue reminder. Registry will do the needful. Next para. Further, issue notice to the respondent number 2 to register AD and as usual process. List the matter accordingly. After vacation, it will be listed.
Till then, Lordship, till then, if the matter can be, till the returnable date, if the matter can be saved, Lordship.
One observation has already been made by the coordinate bench.
That is there.
List immediately after vacation.
Lordship, I kindly fix a date, Lordship.
14, we are reopening 14 meeting. So to take a 14. 16 or 17, I can give you. List on 17/6.
Deputy Ruler.
17/7.
Meet Vijala.
Yes.
I'm praying for question of a PRC case pursuant to a charge sheet under 498A. The petitioner 1 is the husband, 2 is the father-in-law, 3 is the mother-in-law, and 4 is the sister of the sister-in-law. Now, this sister who got married in 2014, there is an allegation leveled against her that she has defamed the informant's character. And the FIR your Lordship will find at page 45. Can you read the vernacular, Millard? There's some wrong in the translation, therefore.
45 in the vernacular is 45.
45. সম্মানপূর্বক বিনীত নিবেদন এই যে উপৰোক্ত 1 নং পদকীয় এজাহাৰকাৰীৰ স্বামী 2 নং পদকীয় শাহু 3 নং পদকীয় শহুৰ আৰু 4 নং পদকীয় স্বামীৰ নিজা বায়েক বাবে সম্বন্ধত এজাহাৰকাৰীৰ জেহাহু হয় 2021 চনৰ 29 নৱেম্বৰ তাৰিখে 1 নং পদকীয়ৰ লগত এজাহাৰকাৰীৰ সামাজিক বিবাহ হৈছিল পিতৃহীনা এজাহাৰকাৰীৰ নিজৰ ঘৰ নাই বাবে দুয়ো পক্ষই প্ৰথমতে কোৰ্ট মেৰেজ কৰিব বিচাৰিছিল যদিও পদকীয়ৰ দাবীৰ বাবে এজাহাৰকাৰীৰ মাকে অতি কষ্ট কৰি নলবাৰী জিলাৰ মুকালমুৱা থানাৰ এলেকাৰ মাদলাবাৰী গাঁৱৰ মোমায়েকৰ ঘৰৰ পৰা বহু টকা অযথা খৰচ কৰি বিয়া দিব লগা হৈছিল পদকীয়জনৰ দাবী মৰ্মে চেগুন কাঠৰ ফাৰ্নিচাৰ আৰু নানা ধৰণৰ উপহাৰ আৰু স্ত্ৰীধনৰ সামগ্ৰী লৈ বিয়াৰ পাছত এজাহাৰকাৰীয়ে স্বামীৰ ঘৰত সংসাৰ কৰিবলৈ যাওঁ কিন্তু 1 নং পদকীয়াক তেওঁৰ কোনোবা বন্ধুতকৈ গধুৰ সোণৰ চেইন উপহাৰ নিদিয়াক লৈ বিয়াৰ পাছৰে পৰা পদকীয়জনে মোক অত্যাচাৰ কৰা আৰম্ভ কৰিছিল। 1 নং পদকীয়াই মোক স্ত্ৰীৰ মৰ্যাদা দিবলৈ অস্বীকাৰ কৰি মোক হকে বিহকে কটু কথা শুনোৱাৰ লগতে 2 নং আৰু 4 নং পদকীয়ানি মোক সতি সন্ততি জন্ম নিদিবলৈ হেঁচা প্ৰয়োগ কৰিছিল। পদকীয়জনে মোক তেওঁলোকৰ স্ত্ৰী বা বোৱাৰী সলনি চাকৰণিৰ দৰে ব্যৱহাৰ কৰিবলৈ ল'লে আৰু সন্তান জন্ম দিবলৈ মই আগ্ৰহ কৰিলে সন্তান জন্মৰ বাবে ডাক্তৰ ডেলিভাৰী আদিৰ খৰচৰ টকা মোৰ মায়ে দিব লাগিব বুলি অন্যায় দাবী কৰি মোক মানসিক হাৰাশাস্তি দিছিল। 2022 চনৰ ডিচেম্বৰ মাহৰ পৰা পদকীয়জনে মোৰ মোমাইদেউৰ মোকালমোৱাত থকা মাটি পদকীকৰণৰ বাবে ইণ্ডাষ্ট্ৰী এটা খুলি আৰু বিল্ডিং বান্ধি দিবলৈ অন্যায় দাবী কৰিবলৈ আৰম্ভ কৰে। মোৰ মা আৰু ভাইটিয়ে পদকীয়জনৰ এনে দাবী পূৰণ কৰিব নোৱাৰাৰ বাবে পদকীয়জনে মোক যেতিয়াই তেতিয়াই চেলু উলিয়াই হকে বিহকে বেয়া গালি গালাজ কৰি থকাৰ উপৰিও 1 নং আৰু 2 নং পদকীয়া শাৰীৰিকভাৱে মাৰপিট কৰিবলৈ লয়। 3 নং পদকীয়ে মোক কাল সৰ্পিনী বুলি বেয়াকৈ কয় আৰু 4 নং পদকীয়ে মোৰ চৰিত্ৰ বেয়া বুলি কৈ মোক লাঞ্ছিত কৰে। 1 নং পদকীয়ে আনকি মোৰ মাহেকীয়া হোৱাৰ অৱস্থাত পাত্ৰ তুলি আন লোকক দেখুৱাই মোক বদনাম কৰে। 2 নং পদকীয়ানি মোক নিজে চাহকাপ কৰিও খাব নিদিয়ে, ফ্ৰিজত তলা মাৰি থৈ দিয়ে যাতে মই নিজে একো কৰি খাব নোৱাৰো। পদকীয়জনৰ অত্যাচাৰৰ প্ৰতি মই প্ৰতিবাদ কৰিলে মোৰ ভিডিঅ' ৰেকৰ্ডিং কৰিবলৈ লয় আৰু সেইবোৰ আনক দেখুৱাই পদকীয়জনে মোক পগলা সজাব বিচাৰে। এইদৰে নানা ধৰণৰ শাৰীৰিক আৰু মানসিক অত্যাচাৰ কৰি 5 আগষ্ট 2023 তাৰিখে পদকীয়জনে মোৰ হাতত চুলিত ধৰি ঘৰৰ পৰা গতিয়াই বাহিৰ কৰি দিয়ে। মই ওচৰৰ এঘৰ মানুহৰ ঘৰত আশ্ৰয় লওঁ। সেই ঘৰৰ মহিলাগৰাকীয়ে পদকীয়জনক ফোন কৰি মাতি আনি মোক নিবলৈ কোৱাত পদকীয়জনে আহি মোক দাবী ধমকি দি গাড়ীত উঠিবলৈ কৈ যদিও পদকীয়জনে নিবলৈ অহা বাবে মই খোজকাঢ়িয়ে পুনৰ পদকীয়জনৰ ঘৰলৈ যাওঁ। কিন্তু তাৰ পিছদিনা 6 আগষ্ট 2023 তাৰিখে পদকীয়জনে পুনৰ অত্যাচাৰ কৰি মোক তেওঁলোকৰ ঘৰ খালী কৰি দিবলৈ কয় আৰু মোক বাজি বুলি অপবাদ দি 1 নং পদকীয়ৰ লগত সংকাৰ কৰিবলৈ হকিয়ানি দি পদকীয়জনে লগ হৈ মোক ঘৰৰ পৰা উলিয়াই দিয়ে। ইতিমধ্যে মই মাহঁতৰ ঘৰত মানুহৰ গৈ মাক লৈ আহোঁ। This is basically the allegation. Now, all of the allegation with regard to dowry, now before her marriage, we have enclosed the WhatsApp messages, which is reverse. It is though the girls will never ask for a dowry, but the demands your lordship will see from the conversation, it is her demand of getting dresses from the designer, the cosmetics. These are all the allegations are manufactured just to bring in within the purview of 498A. Now, thereafter, when the petitioner has filed a divorce, it already has instituted a divorce suit. Now, after the divorce proceeding was filed, with the same sort of allegation, exactly the same sort of allegation, she has filed a domestic violence in Nalbari. Now, in that proceeding also, the defendant number, petitioner number 4, the sister, her name was struck off, saying because there is a finding that there is no such allegation against her which brings within the domestic relationship, and therefore, that order has not been challenged. That order has attained finality. Apparently, your lordship will see, this is a trifle of marriage. Now, she wanted to stay alone with the petitioner, not with their in-laws, and out of that, this FIR has been launched. And this sister got married in 2014. The order passed by the Nalbari court in page 104. (13/3/2025), and this proceeding was instituted. My lord, to kindly see page 103. After the divorce proceeding was filed by the petitioner on the ground of mental cruelty. She has also asked for maintenance also. in the from the Nalbari portion, in the Nalbari portion.
So now this case has already been charge sheeted.
This case has already been charge sheeted and the cognizance has been taken by order is 86. And in the charge sheet also, if your lordship will find page 84, 85 is the finding. Collected information and statement of victim and witnesses for during the course of investigation offense under 498 made out against the alleged accused, Dipankar Boro, Kirda Boro, Bipin Chandra Boro, all the family members. Everyone has been dragged in. And if lordship has read the FIR, assuming my lord that the allegation is against the petitioner number 1, but 2, 3, and 4, there is no such allegation which brings them under the purview of 498 even. And the parents are well, they're senior citizens, old age. So lordship, just for a moment, my lord, I'll show my lord the allegation what she has leveled that the furniture that was asked for. Page 48, your lordship will kindly see. These are the designs which she shared with him, and your lordship will kindly see the conversation below. The page 49 also, my lord, the continuation.
Good only she is planning to make the furniture good furniture.
It was not demanded by the. Now what she is projecting that it was demanded by her, the petitioner. It is contrary, my lord. In fact, if your lordship will read the conversation, your lordship will find it was the petitioner who has been demanded.
Muk Mercedes lagibo. She's thinking, demanding it, not demanding, it's out of thing.
Yes.
She wants to get a good life, in fact. Anyway, yes, Sharma. Anything to submit? Is there any prayer from you?
My lord, the proceeding, my lord, the next date is 22nd of July 2025.
22nd of July.
22nd of July. Let the proceedings be stayed and the is there the LCR may be called for, my lord.
And notice to the my lord, respondent.
Informant eyes. In fact, and as per my instruction, my lord, the 161 statement of the witnesses has also said nothing, my lord. All the neighbors are been investigated, my lord. Except the victim, nobody has said. Okay.
Had Mr. B. Kaushik, the learned counsel for the petition, and also had Mr. B. Sharma, the learned additional people appearing on behalf of state respondent. This is an application under section so and so, in connection with so and so. Issue notice to the respondent number 2 to register TD and as usual process. No formal notice is required to be served on the state respondent number 1. However, copy of the petition may be served during the course of the day. Further consider also call for the scan copy of the LCA. Registry will do the needful. Next para. Further considering the submission made by learned counsel for the petition and the other relevant documents which has been already been annexed along with the petition. The further proceeding in case number.
PRC case number 450 of 2025.
450/2025.
Pending in the court of additional CGM Kamrup.
Additional CGM Kamrup and the state till returnable date. List the matter accordingly after.
Grateful, miss. Highly blessed.
4 weeks.
28.
The fag of the day. Take end of the day.
End of the day, because it's already
And
four.
It's not a time to argue or not to time to not to listen the argument. Now let's
4:30
short
actually, I
question.
have to go to, Justice Pathak chamber, something is there.
Oh.
Anyway, your
No, I-
commission, what is your submission?
Whatever you say about internal dispute. In Dibrugarh, there is a popularly an hospital is there known as Arogya Bhavan. Now.
In Dibrugarh.
At Dibrugarh. Arogya Bhavan is big, is a social organization. A society is registered, they manage the hospital. Now, the petition number 1 is the secretary of that association. And others are also office bearer. Now, what is the allegation is, by this complainant is, that regarding the accounts, etc., of the association. Now, he said that he made a complaint against the auditor of the association, one chartered accountant named Binoy Shah. Now, the Binoy Shah.
Complaint was made against whom?
Against not Binoy Shah, against us.
Acha.
Now, what happened that the Binoy Shah, the chartered accountant, he lodged a complaint against this complainant before the police station, Dibrugarh, saying that this complainant has made some threatening to him to change the audit report of the association. Now, subsequently, Binoy Shah withdrew the complaint by saying that it is all is after the misunderstanding he has lost the complaint. Now, this complaint has filed before the CGM by this complainant, my lord. And in the complaint, he says that on 11/9/2022, in paragraph 4 of his complaint, that the Binoy Shah has lost the complaint. And his allegation is that behind back, we are the persons instigated Binoy Shah to lodge the complaint before the police. And that complaint circulated in social media. This is basically the complaint petition is. Now, the illegality committed by the learned CGM of Dibrugarh is that the complaint petition once filed, the learned counsels of this complainant, he made a prayer before the court to send the complaint to police for registration. And accordingly, the learned CGM Dibrugarh has forwarded the complaint to the police for registration of a case. Lordship would appreciate that exercise of the power by the learned CGM is under 156(3). Now, before doing so, as per the Supreme Court recent judgment authored by Justice B.R. Gavai in 2022, there are 3 preconditions. Number 1, whether you lost FIR before the police or not. This is the first, 154(1). Then if that FIR not registered, then your second option is to raise objection before the superintendent of police under subsection 2 of 154(2). That the police has not registered my complaint. Then if thereafter also complaint was not registered, then you may approach to the court, but that complaint petition has to be supported by an affidavit. Now, affidavit has been annexed with the complaint petition, but it is not an affidavit in accordance with law. My lord, kindly have just for a moment look into the complaint petition, page 23. Page 28 is the affidavit. Now, lordship, kindly have a look that whether it's an affidavit or not. No oath, no affirmation. It is at best can say to be a verification. 28. And no document, no averment has been placed that he has lost the FIR before the police. Lordship, kindly have a look at para 7.
Para 7 of the complaint?
Yes, page 26. On 10/10/2022, the complainant lodged a complaint to the police authority Dibrugarh, but till today neither the statement of the complainant has been properly recorded, nor any case has been registered against them. Now, this complaint, alleged complaint, but saying by the complainant not annexed with the complaint petition.
But the allegation brought against you, what is your allegation against you?
My against, in fact, the para number 4 of the complaint petition, my lord, and it's very low, saying that the Binoy Shah, the chartered accountant who is the auditor of our organization, he lodged a police complaint against this complainant before the police. And we are the person behind the back of this complaint.
So it is registered under which section, this case?
This case has been very interestingly registered under section 120B 200, my lord. And court has also taken cognizance under section 200. 200, how could it could be registered? 420, cheating. He is one of the member of the organization. And we are the secretary, president, etc., etc. And we are doing nothing. Against me, the allegation is that we have put that complaint of Binoy Shah in the social media, in the WhatsApp group. That complaint was circulated.
That's why it is on 500.
Yes.
That's why 500 is there.
That's why the 500. Now, the charge sheet was filed after the investigation under section 120B, 200, 420, 294, 506, not 500. 120B, 200, 420, 294, 506, 34. Now, just to please the judgment, because this is just only the law point involved, my lord. I am not pressing upon the facts now at the motion stage. Now, only the law point I have just pointed out. Lordship, kindly have a look at paragraph 24, 25, and 26. 3 paragraphs, small paragraph, my lord.
24?
24, 25, and 26. They are the precondition of exercising the power of section 156(3). There must be a complaint before the police, there must be a complaint before the superintendent police, and there must be an affidavit. Otherwise, you cannot exercise 156(3). So this is a mandatory provision, my lord. So without exercising that, the CJM has the initiation of the entire motion is bad. So at this stage, I am only requesting, my lord, to issue a notice because respondent number 2 is there, and until the returnable date is stayed at this stage.
Yes, bro.
Lordship may kindly see my lord, page number 32, my lord.
32.
32, my lord.
32.
FIR complaint was lodged, my lord, in the year 2023, January, my lord.
No.
2023 itself the complaint was lodged. Then it was registered, my lord, then it was investigated. 2024, my lord, investigation completed, my lord.
Correct.
They are not, my lord, agreed by the FIR, my lord. Neither the investigation that.
We had no knowledge, my lord. Once we received a notice, my friend, just a minute. Once I received a notice, my lord, summon, the next date is 23/6. Then we came to know and obtained the certified copy. We do not know anything. Everything has been behind our back. That is
So you want to say that the FIR was lodged on 23?
23.
01.
20th of January 2023. Yes, yes.
It was registered, my lord. This FIR was forwarded to the police, my lord. And it was registered on, my lord, 18 to 2023, my lord.
Correct.
Thereafter, my lord, investigation was done. Investigation completed on 24/6/2024. By submitting charge sheet, my lord. Now, my lord, after filing of the charge sheet, my lord, the trial court has, my lord, to cognize the issue summoned to them.
There is.
My lord, my humble submission, let the opposite party appear, my lord.
That's my. I am humbly submitting. Today we cannot dispose this matter, my lord. My only limited submission is the very initiation of the proceeding is wrong against the law. And this is number 1. Number 2 is that the charge sheet does not say anything against us. Absolutely civil dispute. Absolutely. But it is an internal dispute between the society. It is not a public wrong. Internal dispute.
As far as the charge sheet is question concerned, my lord, Lordship may kindly peruse page number 40, my lord.
40.
40 last paragraph, my lord. That is the, my lord, last of the case, my lord.
40
Page number 40, my lord, article.
or just last paragraph. Nothing said against us.
Initially, my lord, FIR was lodged against this complainant, my lord. On the behest of by this, my lord, accused person, my lord.
No.
Then, my lord, that is, my lord, that is affected, my lord. May I read, my lord?
Oh, at the behest.
The brief fact of
That's
case
the
is-
complaint.
Yes.
That's the complaint.
Initially, FIR was lodged, complaint was lodged against this, my lord, informant, my lord. Later on, it was withdrawn, my lord. And allegation is that, my lord, on the behest of, my lord, this accused person, my lord.
He lost it.
The person, that person lost the FIR. Which was, my lord, fake and, my lord, frivolous. That is why, my lord, he lost this complaint, my lord, which was registered as an FIR. At this time, my notice may be issued, my lord.
And learned court, while taking a cognizance, my lord, saying the Peru's documents, no documents, along with the charge sheet. The charge sheet only includes the 41A notice. Nothing. That complaint of Binoy Shah, not there. No WhatsApp message, nothing. No documents were seized. Bare allegation.
Heard Mr. Dr. Dr. Dilanet. Assisted by Mr. S. Deca, Dilanet counsel for the petitioner, and also heard Mr. R.G. Borwa, Dilanet additional PP, appearing on behalf of state respondent. This is an application under section so and so, in connection with so and so. So we give a issue notice to the respond number 2 to register dairy in as usual process. No formal notice is required to be served under state respond number 1. However, copy of the petition may be served during the course of the day. Also call for the scanned copy of the LCR along with the case diary. Next para, further it is submitted by Mr. Dr. Dilanet Senior Advocate that the present case has been lodged against the petitioners who are the employee,
The office bearers.
Of the company, no?
No, of a society.
Office society. Poster. Initially, a case was, an FIR was lodged by the internal audit, the Mr. Binoy
Shah, chartered accountant.
Binoy Shah, the chartered accountant, against the complainant, but thereafter, the complaint was withdrawn by said Binoy Shah. Post-op. After withdrawal of the said complaint, the present complaint has been lodged against the present petitioners with the allegation that said Binoy Shah had lodged the earlier complaint only on the instigation of the present petitioner, which was made viral in the social media. But surprisingly, at the time of taking cognizance, the charge sheet was not accompanied with any kind of document, nor the police investigated, nor any document was collected during the investigation. Further, Mr. Dr. Dilanet Senior Advocate submitted that the present complaint was lodged before the learned CGM, which was sent for investigation under complying the provision under section 156 subsection 3 of CRPC without complying the other provisions which are required to be complied with before sending a complaint for registration before police station before sending a case to the police station for registering and submitting on FF. In that regard, he also relied on a decision of Honorable Supreme Court passed in passed in case of Babu, Venkatesh and others. Packet reported by 2022 5 SC base 369.
639.
Oh, sorry, 639 packet of Didibuapo and emphasize on para 24, 25 and 26 of the chain judgment. Next page, in citing the judgment, it is submitted by Mr. Doctor that before sending a case for registering in the police station, there has to be 3 compliance. That is, first, there has to be 1 FIR, and if the FIR is not registered or acted upon, then 1 complaint has to be made before the superintendent of police, and thereafter only the a complaint can be, case can be filed before the court with an affidavit stating all the by stating all the relevant things in the with an affidavit, supported with an affidavit. But here in the instant case, there is no mention about those. There's no mention about the registering of the filing of an FIR or a rejection. No, but there is no compliance of those, or there is no such compliance in the while filing the complaint before the learned trial court building. More so, the learned trial court also took cognizance without ascertaining those provision which is to be mandatorily met, which should be complied with. In view of according full stop, Mr. Doctor accordingly submitted that till the returnable date, the proceeding against the present petitioner pending before the learned court of so and so, what do you or no, case wrong. Learned court below may be state till returnable date. Considering the submission made by learned counsel, Mr. Doctor, the further proceeding is hereby further proceeding in case number so and so pending before so and so is state till returnable date. List the matter according after 4 weeks. You text it.
Yes.
No, see, we cannot just it is not the permanent ban, so we can
Interim was still today in my case, item number 30. 13. Interim was still today. Item number 30. 13.
Interim
It
be
may be
extended.
extended, my lord.
Item interim be extended till next date of listing, list accordingly up to 3 weeks.
Item 20 also.
Everything.